Hey, chat. Good evening. Welcome to the show. It's Friday night, and it's going to be a Cope stream. This is a Cope stream, and this is a little bit bigger than a tin of Copenhagen. It's model masking putty, but like if you know how to do it, get your dip slap going because we're Copenhagen tonight, chat. This show is sponsored by Copenhagen. Uh, oh boy, oh boy. I mean, I don't know how else to say it, but yeah, we are a Copen and a Sneeden tonight, chat. I don't know how to say it otherwise. We are a Copen and a Sneeden. Such is life. Such is life for such is life. That's life, they say. Uh, you're riding high in April and you're coping in May. But as you change that tune, May will probably get felted again sometime in June. Sadly. Well, last to say, I missed a few chats. I am sorry. It was tough. You guys made like a million of them. I was trying to keep up there. I'm so sorry. If I missed them, my bad. My bad. Fair Froze says, no way Greer actually caught a dub. It's not that he caught a dub, it's we caught an L. And the L isn't really the end of the world here, but we'll get to what it is. And hold on. Hey, Clyde, you want to come up here, buddy? Or are you sniffing the bowl? You sniffing that? Yeah. Hey, come here. Come on. Come on. Come on. Hey. Oh. There you go. There you go, Bubba. He was eating dinner. Hi, Clyde. Such a good boy. He's a good boy. He's a good... Why does my screen look so... There we go. That looks a little better. God, it looked like weird, horribly lit. And it's like hazy light effect going. What do you think, Clyde, huh? Are you just going to lean back now? I got you, buddy. I got you. There you go. There you go. Yes, but we had some other losses today as a world. R.I.P. Chuck Norris. Clyde, hold on, buddy. You're not in the right spot. There you go. There you go, Bub. It's okay. You're okay. So he's a good boy. Clyde's looking lean. Well, he gets trimmed up. He always looks good. Well, gee, okay. You're not burping in my face, buddy. Ugh. Fucking smells like shit. Oh, that smells like crap. He's burping right in my face. We're not doing that. I'll adjust my mic when I'm ready. But yes, he's looking lean. Yeah, well, when he gets trimmed up, he looks good. He looks like $1 million because he's a good boy. Yes. No bonbon this weekend. No bonbon this weekend, though. Chuck Norris told a woman to calm down, and she did. Yeah, and Chuck Norris, 86 years old. I remember when I was in college, and it was funny at the time when I first got there, they told us there was this thing you could call, which was like the information line. And you call this thing, you could ask them questions, and they almost always had an answer. I didn't realize this at the time, but it was somebody like probably the first 2 months I was at school. When I was at Bowling Green, I was like, oh, this is so cool. And then I realized what it was. It's somebody, you called the line, and it was somebody at the front desk in the student union who just sat there and Googled shit. But it was a real thing, and it was fucking hilarious because one of the things we were talking about was how old is Chuck Norris? And, this before Wikipedia, and somebody's like, oh, he's like it was at the time he was like 2004 that had been, he was like 64 or something like that. And I'm like, there's no way he's that old. I think it was at the time. And we're like, there's no way. And it turns out like, yeah, he's 100%. Like he was like almost 70 at that point. You're like, whoa, pretty crazy. Pretty crazy. I know it's a cool story. That's why I told it, because it's my story and it's cool. So, super beautiful noise. Way to censor me, mods. The mods don't censor. YouTube might be doing it, but no, my mods don't do anything. They're told to be apathetic as long as you're not violating TOS. As long as you're not doing that, then you can say whatever the heck you want. That's how we roll here. So let me just check. Yeah, I don't see nothing from them, and I'm reading the chat, and I can see what they've done or not done. Yeah, nope, that's YouTube. Sorry. Sorry, but that's Mama Susan. The dead hand of Mama Susan controlled from the grave. She's like, suffer chat. She's like, suffer viewer. Suffer super beautiful. Then I will say it again. I hate Josh and I want him to lose. Okay, well, you can say whatever the hell you want. I disagree, and I don't see why that's a good thing, but hey, we all can cheer on what we want. Did you ever see 12 Angry Men? Was most of the way through here on YouTube until your stream started. Yeah, I've seen it. I saw that. Oh, it's been a while, but yeah, no, I've seen it. It's a good movie. Good movie. Peter Fonda does a great job in it. Peter Fonda does a great job. Chuck Norris didn't die. We did. Yeah, YouTube is getting ridiculous with the auto modding. I mean, my mods are gay. I mean, that's why they're mods. They're Jannies. Like, they're the scum of the earth. But they don't do that stuff. Let's see. What year do you think it is, Sean? I don't know. The year of the dragon? I don't know. Do you still got Afro Man song stuck in your head? Oh, yeah, I do. Yep. Oh, hell yeah, I do. All the stuff on Twitter is still funny. And apparently the attorney in that case has sent a order to the court reporter to prepare a transcript of the jury selection, which I don't know what he's going to do with that because they help pick the jury. So I don't know what they're going to appeal at this point, but it sounds like the parties involved are not giving up and they're going to appeal. So that'll be hilarious to see. And I'll be covering the appeal and going forward on that stuff. It also sounds like it sounds like all the stuff with Little No Lisa. Not all the counts for her were unanimous. In Ohio, you don't need a unanimous jury on a civil case. You need 75% of the jury. So when you have 8 people, that requires 6, for those of you in Rio Linda, to vote one way or another. It sounds like she got a couple of counts of where only 6 jurors found Afro Man not liable. Yes, the goddamn A-logs. Yes, I've seen the Democrats erasing Cesar Chavez. Yes, this is hilarious with the revolutionary communist out there. Because Cesar Chavez was vehemently anti illegal immigration because the United Food Workers Unions, with all the fruit, like picking in the fields, the fruit pickers, they unionized. And how did they get around them? What were the scabs at that point? Illegals from Mexico. So they were vehemently anti-illegal immigration, and they would go around and, like normal strikers go fight the scabs. They would go beat illegals and chase them. They set up a thing called Operation Wetback, where they were going down to the border and they were like vigilante border patrolling. Like they would know where the illegals were crossing and would like beat them and ambush them and send them back to Mexico and scare them off. Like Cesar Chavez was very, very, very illegal immigrant. Like it was very much only for legal immigration. They got to get rid of that because Cesar Chavez Day is like March 31st. So they got to get rid of that. But yeah, they are just completely plastering him over because he no longer serves the vanguard of the revolution anymore. Because of that, they're going to get rid of him. They're going to get rid of him, and that's going to be that's a very interesting thing. They're willing to sacrifice him. Just like writing out Trotsky and other party members. They are really good. They're really good at it, which is a surprise. Kayla says, I want him too tight. What? Um, Tech Guy Salsa actually have jury duty on Monday. Well, good luck, man. Good luck on that. Hope you have fun. Sadly, you're not going to have as fun as the Afro Man jury had, but maybe you do. Maybe it'll be good. Oh, you said there should be a 900 and 100 in there. Oh, well, Green Caps, thank you. Thank you for your thank you, man. I'll check that out real quick. Um he's talking about over at potentiallycriminal.locals.com in the safe house. And I hate how like you could pin something only temporarily, and it's a little frustrating when they do that. Pin till removed later. Let's see here. Oh, actually, hold on here. I need to unpin. I pinned the wrong thing. Pin. Yep, there we go. Why is it doing that? Stop. But anyways, green caps for oh, I appreciate that for $90 saying let's go. Well, thank you, green caps. I appreciate that, man, very much. Very, very much. Thank you for that support. Thank you. Thank you so much for 90. 90 and you said 90 and then 100 in there? Wait, you mean wait a 900 and a 100 in there? Is that what you mean? Oh, hold on here. Oh, no, it says no. Okay, I just want to make sure I saw that right. But anyways, thank you so much. Thank you so much. I appreciate it so much. I don't know. I still don't know what I did to have people like you out there in this world, you guys. I appreciate every minute of it. This is um such a cool experience. Doing something where I just sit here and babble and you guys are apparently like, you know, jamming and grooving to it. And it's like, never would I thought that happened in a million years. So thank you, Green Caps. Thank you so much. Let's see here. I'm eagerly awaiting the Ralph and Scarlet tapes. Yeah, that's gonna be something. Let me tell you what, man. I am oh, I don't know if I want to see that stuff. I don't know, but apparently Ralph's now talking about going to Vegas and getting married, and it's like, more, blood for the blood god, skulls for the skull throne. Although apparently Gabe Hoffman is now on the warpath because apparently Scarlet is a vehement like white supremacist, where you're like, okay, so I don't know how that works. If she's a white supremacist, she was paid to perform for black.com. So I don't get that one necessarily, but as Private Joker told us in Full Metal Jacket, it's the Jungian thing. It's a duality of man. White supremacist, but also working on black.com. It's the yin and the yang. David saying, I only time out one person. Well, T-Rex says, to me, the year of our Lord 2014 was only 3 years ago. It feels like it. It feels like it, man. Pirate Tomsky joining back up. Thank you so much. Thank you so much for being here. Brad said Attorney David Osborne's interview with YT. Do you mean Young Turks? Mike Crawford, great. Congrats on him getting that interview, because I don't know what he did to get it, but he did a good job on that one. He had Afro Man on, but I don't know if he had his attorney on. But yeah, awesome. Yeah, I mean, there is times where you will do that to manipulate your client, to manipulate the jury, like totally. Like, it doesn't surprise me that that was the plan. It's just it wasn't as humiliating as it was hilarious is the problem. But that's the risk you take when you do demonstrations or things like that. You may think is emotional and scores points, everybody may just sit there and go like, ah, ha, ha, ha. It's a risk you take. It's a calculated risk, and it's a risk he had to take ultimately. Any real socialist is vehemently against illegal immigration. Yes, well, that's true. Let's. Oh God, I'm a couple minutes behind. I got to catch up here, chat. Sorry. Let's see here. A total of 100 should show up. Okay, well, thank you so much, Green Caps. I'm a professional babbler. Yes, I'm 100% that. And you guys will think, wait, now you love Scarlet? Yes, I'm a manipulator. That's yes, yes, you manipulate. Oh, YouTube. Okay. Well, I thought you meant YT is the young jerks on the. Well, there. Also, YT means white. I'm sure Black is Talmudically owned. I mean, I think all those like Pornhub is, and a lot of those porn studios are. At the end of the day, and then the Ralph and Scarlet marriage was promised to us 3,000 years ago. Oh God, I don't know if I want that. Tori LeWhite says Gabe Hoffman of Hoffman Tactical. No, Gabe Hoffman of An Open Secret. The Gabe Hoffman of Keno Casino notoriety. The hedge fund manager. So, all right, let's get to this chat. We got some. EDW Raptor says last. Ace Ventura for €2 says banana. Because the banana comes in denim, chat. Don't let him gaslight you. The banana comes in denim. So, let's get started. We'll catch up on the other stuff here. Where we last left off, the Russell Greer lawsuit against Josh Moon and the farms was still basically kind of like up in the air. We hadn't really had a resolution to things. And we were waiting on the big thing, kind of the looming issue, was the motions to dismiss. And ultimately, would the farms be able to get sanctions or just get the case dismissed as a sanction against Russell Greer for his discovery violations, but also just his general inability to prosecute the case. And when I mean prosecute, pursuing a tort action is considered the prosecution of it, chat. So not like actual like prosecution, just because I've said that before and people get all weirded out when I say that. And remember, Russell Greer is suing the farms because the farms are alleged to have, Josh Moon and the farms, through Lolcow LLC, are alleged to have engaged in contributory copyright infringement, meaning they didn't specifically do it, but the people who posted things to their website on the farms, they didn't stop it. They didn't stop it, and they are alleged to have basically induced it or basically made an environment that would support it and allow for it to happen. And that's why Russell Greer is suing them. Now, this has gone on since 2020. I mean, this has been dragging on now for over half a decade. And we can, we'll start with just where this began out in the District of Utah for some reason, which we still don't understand at this point. It was filed in the District of Utah, September 16, 2020. And where we left off, chat, was right here at the end of January. Russell Greer was seeking to disqualify Matthew Hardin for a bunch of different reasons, mainly that he was alleged to have been terrorizing Russell Greer by investigating the false and the fallacious and repeatedly frivolous statements and comments made by Russell Greer to the court, and also made during the process of communicating between himself and Matthew Hardin, as you still have to do between parties. And we are now into February. Notice, this is kind of quiet. I forget if I had said they would get to 500 by St. Patrick's Day, or if they would get to 450 by St. Patrick's Day. But if I said 450, they got to 450 by St. Patrick's Day. But just look at this, guys. We have not resolved this case. And we're already at entry 454. Now, we covered the Corey Rich's murder trial. They were up to docket entry, I think 1,200. But that makes sense in a criminal case where they're seeking, it's a high profile thing and there's a lot going on. Yeah, there's going to be a lot of motions, but this is just ridiculous. This is way too many entries. There's way too much stuff going here. Now, where do we start out at? Well, we're going to start basically here on the 9th. The motions to disqualify were challenged by Hardin and the Farms, and we're not going to go too buck wild into some of this stuff here, but I think it's helpful to take a look at what we're addressing in this situation. And I know in the meantime, Russell Greer has been dealing with his evictions out in Nevada or Nevada or Nevada. Many of these he's appealing and attacking his landlord and trying to sue his landlord. And they're all kind of crashing and burning. And we find out that Russell lives, well, like you'd expect a lolcow to do. Yeah, we know why it's in Utah. We just don't want to rehash it. I mean, it shouldn't be in Utah. I mean, at this point, it probably should be. It should have been in Nevada, but there's, not a whole lot we can do about that at this point. So it's the defendant's opposition to the emergency renewed motion to disqualify. Remember, Russell Greer filed an emergency motion like, oh my God, no! Help, judge! He's making me look bad. Matthew Hardin did switch tactics. Instead of writing a thorough response, there was entry number 446 should be denied for the same reasons his original motion should be denied. And it says, without limitation, we assert the renewed motion is nothing more than a duplicative and burdensome filing, and it fails to show any good cause for disqualification or the relief. Basically, we're saying, Judge, go back and see what we cited. We're just reiterating it here again. We're not doing that this way. Done. And this is an effective way to handle it at this point. Signed by the Hardin Law Office, Matthew D. Hardin. Good for him. Good for him trying to cut down on some issues here. Seller says Hardin ever won a lot, or not Hardin, but has Russell Greer ever won a lawsuit? I don't think so. Don't think so. No. Now we move on, and Ace, you're saying how could the judges take Russell serious? It's not that they're taking Russell serious. It's just they're. We'll get to what's going on here. Now, from here, the motions to dismiss had been filed and the responses had gone on. And we now move into the report and recommendation of the magistrate. Because remember, the judge in this thing had looked to the magistrate and said, hey, man, you need to take a look at it. You do the research. You address everything. You make a report and findings and send them to me. And you might say, well, that doesn't seem fair. That's what a magistrate does. You do the judge's crap work. And that's how it goes. Just like any job out there. You lose 100% of the lawsuits you don't file. That would be a hilarious personal injury billboard. You lose 100% of the ambulances you don't chase. That would be hilarious. Oh my God. That would be something. So there's a report of recommendations here, and they talk about, once again, pro se plaintiff Russell Greer filed his original complaint. And basically they're claiming that they copyrighted on Russell Greer's book, Why I Sued Taylor Swift and How I Became Falsely Known as Frivolous, Litigious, and Crazy. And the copyright of his song entitled, I Don't Get You, Taylor Swift. And then it says, obviously the Farms are a website built to exploit and showcase those who are eccentric and weird. You could also say funny and weird, to quote other people. Wait, is that Saul Goodman's tagline? I'm not going to lie. I've never watched Better Call Saul, so I don't know if that is. But notice they also point out the magistrate is just citing why this is how he has the authority to do this. Well, it was referred to me. And they point out that although Greer has said they were liable for all kinds of things, he only sought damages for the book and the song, as those have suffered the most damage. So Russell Greer's kind of forfeited his other claims and passed up on the ability to do those. They talk about the whole history of it here. We're not really worried about the history, but they go back through the initial beginnings of the case. They talk about, things got appealed to the 10th Circuit on the initial motion dismissed, which had been granted. Russell Greer won at the 10th Circuit, And they said that he did meet the elements of citing a claim upon which relief could be granted, so it survives that initial issue, and it came back to the court in Utah. So on remand, the underlying judge recused, and that makes sense because if you've already said, "Hey, I don't think there's enough here," and the appellate court says, "Nay, pa, don't do that again," you kind of have to be recused because you've already thought there wasn't anything there, and it's not going to help you. So it's better for the sake of um, the appearance of legitimacy and propriety that a new judge be appointed. Um, they go on here. The farms also moved to substitute Lolcow LLC in place of Kiwi Farms, asserting that because Lolcow's a legal entity that does business with Kiwi Farms. And they pointed out that, several months after all this happened, Russell Greer filed for leave to amend his complaint. Russell Greer got to do another amended complaint. And remember, this is so far after the initial filing, he doesn't get the right to amend it without leave of the court. And they point out here that in the contributory copyright infringement situation here, he alleges that the stuff was copyrighted without his permission. And after discovering his book had been posted without permission, he sent a bunch of emails to Josh Moon saying, "Please, Josh, please remove them." And in response, Miss Joshua Kana Moon posted all the email requests, stated he would not consider them. Russell then later emailed the farms a takedown notice. And then eventually, Josh responded by posting Greer's DMCA notice and a farm on the thread on the farms, as well as an email stating he was claiming fair use protection and would not take down any posts on the farms. And they're arguing that makes it knowing, willful, materially contributing to this. And that's the ultimate basis of the claims against Josh and the farms. Now they talk about the previously filed motions to dismiss. There was once again an amended complaint, and that means there was a new dismissal motion because you get a new chance to attack it. They point out though, the court denies the motion to dismiss for two reasons. First, they waived any Rule 12b 2 through 5 defenses for failing to include them in their first motion to dismiss, meaning the one where Attorney Scortis was involved. He did not file a motion to dismiss alleging those things. And guys, remember, under Rule 12b, you have to file those. If you don't file those right off the bat, they are deemed waived in civil procedure. And those things are the, how to present the defenses here. Well, these are things you would attack. Lack of subject matter jurisdiction, no personal jurisdiction, improper venue, insufficient process, insufficient service of process. The big one, failure to state a claim upon which relief can be granted, and failure to join a party. Those are the 7 things you can do. Notice the court is saying he did not do a bunch of these, that they've been waived because they weren't properly brought up before the court. So, and they say when the court treats a motion to dismiss under 12b6 and 12b7, they treat them as a rule for judgment on the pleadings. The motion still fails. And a judgment on the pleadings, it says, judge, basically, if everything is right, under summary judgment, who wins? And they're saying, you know what, we're dismissing it. And they point out all these have been waived. These prior things have been waived here. And they point out that a party that makes a motion under this rule must not make another motion under this rule, raising a defense or objection that was available but omitted from the earlier things. You are limited in how you can file these. If you don't file them, you waive them. You waive these if you admit them from a motion. And they say the first motion only raised the defense of failure stated claim upon which relief can be granted. And this is therefore they waived 2 through 5. And they argue, though, in an attempt to avoid that result, they contend their motion filing an amended complaint means they now have the opportunity to relitigate this case from the beginning. And they argued that the complaint is vastly different and differs markedly from the original complaint. And I understand what they're arguing here, and I think they should be allowed to deal with it. And it says that because of that, they're permitted to bring a second Rule 12 motion to address any new allegations. And the court says, although true, if an amended complaint contains new allegations, you may bring a second Rule 12 motion. But also true is the motion can be directed only at the new allegations. So if Russell comes up with 2 or 3 new theories of liability, the motion can only attack those new things. So once again, it's kind of like this idea of res judicata. You can't relitigate something if you've waived it or it's already been decided. So you don't get to, and they point out that the filing of a amended complaint will not revive the right to present motion defenses. They're available, but that were not asserted. Because of that, they fail. They point out that the amended complaint, the allegations are relevant to 2 of the defenses at issue: lack of personal jurisdiction and improper venue under the Rule 3 and jurisdiction under 2 are not substantively different from the allegations of the original complaint. They say, as for insufficient process and service of process, there's nothing new in the amended complaint. And they say, moreover, the inconsistent positions about the allegations undercut their own arguments. And they say the defendant's argument in their reply that Greer's amended complaint is vastly different and differs markedly runs entirely counter to their assertion in the motion that the complaint is substantially similar to the original complaint. And you know what? I mean, ultimately, you argue where you can on that. So you might make a contradictory claim, but you do it anyway if that's what you have to do. So they failed to show that they are permitted to bring a second motion raising these defenses under 12B2 and 12B5, in between. Therefore, the motion should be denied. So yeah, it's already starting off as a chat. Once again, get that dip tin ready. Get that dip tin ready. Oh God, it's been so long since I did it, and this is a little too big, but like, oh God, I'm out of practice, so doesn't work for me anymore. Ace, Rule 12 covers Rule 12 right here is the rules of civil procedure. And this covers defenses and objections. When do you present them? Motions for summary, motions for judgment on the pleadings, consolidating motions, waiving defenses, and pretrial hearings. And it talks about the time to serve responsive pleadings. In general, you must serve an answer within 21 days after being served. They talk about if you're serving the United States and its agencies, officers, or employees in an official capacity. If the United States officers are sued as individuals, how does that work? They talk about the effects of motions that are done. And then the defenses that you might normally assert. If you're going to assert some defenses here, so like you're going to challenge subject matter jurisdiction, you're going to challenge a lack of personal jurisdiction, you're going to challenge all this stuff. This is what you would cite, and this is what you would use to attack Rule 12B. I hope that makes some sense there for you. They talk about a motion for judgment on the pleadings. This is a set of rules to govern how civil cases are to be done. And this is at the federal court level, and all the courts have to obey these rules. These rules are passed down on high from the Supreme Court and advisory groups. So, is Josh Moon going to jail now? No. So, I hope that answers your questions, Ace. If it doesn't, let me know. Don't Google Rule 34. Don't do that. It is a little weird, I will say, seeing the blue highlights, but hey, that's when you're a federal judge, you can do whatever you want. Federal magistrate, you can do whatever you want. You can do whatever you want. They point out here that they're arguing this as the court's treating this as a judgment on the pleadings, and the court still denies it. They point out the 10th Circuit have previously recognized that district courts struggle with the question of whether you can raise previously available arguments before first filing a responsive pleading. And they point out that a district court consider these successive motions as a rule for judgment on the pleadings. Okay. It'll happen thrice before the rooster crows. How am I reading without my highlighter? You guys are just mean. You guys are just being mean today. Now, they say turning to the ultimately this issue here. They point out that the arguments in Rule 12b-6 fail. And remember, 12b-6 is failure to state a claim upon which relief can be granted, meaning even if you consider this true, this actually isn't something under the law where we can fix it, Your Honor. So it has to die. They say they point out they're claiming that Russell has not adequately pleaded copyright infringement. The embedding of a link on a website does not give rise to copyright infringement liability. They argue Section 230 protection under the Communications Decency Act. And they're arguing fair use defenses that bar the claims. And they first provide legal standards, and then they demonstrate why each one fails. Now, the court at this point will accept as true well-pleaded factual allegations, and then it determines that the plaintiff provided enough facts to state a claim that is plausible on its face. And that's how you do this. Remember, you look at the material in the light most favorable to the plaintiff, and then you determine, you make the presumption their facts are true. Well, then how do you address it from there? They point out, in addition to addressing and accepting the facts as true, the court views them in the light most favorable to the plaintiff, meaning that you draw all reasonable inferences from the facts in favor of the plaintiff. And then he said, rather than judging whether it's improbable, it must be enough to raise a right of relief above the speculative level. That's all you're trying to argue here. They point out it just doesn't work. And they point out that Greer adequately pleads contributory copyright infringement. And basically they're going to say, even though Matthew Hart had tried to argue the 10th Circuit's decision is no longer controlling, except for the publishing of the precedent, they're pointing out it fails. Why? And they're saying because he still did it according to the 10th Circuit, he's still okay. And he says that these allegations about contributory copyright infringement are substantially similar to those in his original complaint. And they say, given that similarity, and remember, they're basically saying because he already won on these facts, he's basically alleging the same facts again. So we're going to determine that he won, he would win again here, and probably would, given how these courts handle it. And number two, I don't think they'll be very happy to learn that he's been bouncing around like this. How this is going to look. But they're still going to say, we uphold it. Airdude says, I'd rather model a tank. Well, we'll do that later. We'll work on the elephant later. They point out that the embedding can give rise to copyright infringement liability. They're arguing as of right now that can happen. And they say they're relying on a case called Great Bowery versus Best Little Sites. And they argue that embedding a link cannot give rise. And they talk about in that case, which dealt with infringement of copyrighted images, Judge Barlow, so the same judge we're dealing with, adopted what is known as a server test, which was set forth in Perfect 10 versus Google, and later affirmed by the Ninth Circuit. Now, this is where we start to get what is that? They point out if a party displayed a copyrighted image and it stored on its own systems, then it had infringed. If it displayed an image by merely linking or framing content from other websites, then it had not infringed. And in this situation, I don't think they have. And he says, although that this had been questioned, the server test, he noted the parties had not cited. He was unable to find any appellate cases rejecting his test. So therefore, he claims, I'm applying my test and it must be good, which is a weird standard, but okay. He says, accordingly, they denied the plaintiff's motion for partial judgment on the pleadings and defeated the embedding defense. So remember, they're saying that this is going to be a thing. He can make an argument for the server stuff. They also argue that the allegations read headlong into that case, and they point out that Judge Barlow's later opinion in the same case. They say in the subsequent opinion, Barlow considered his application of the server test and the issue of embedding. In doing so, he concluded a defendant who embeds a copyrighted image on a web page without hosting the image may infringe the copyright. And he later determined that the conclusion is compelled by the text of the Copyright Act, and the court is no longer persuaded by the server test. So they're putting out, fuck the server test. It didn't even matter. After a while, he changed his mind. They move on to AFIX saying Wales passed a law making it illegal for politicians to lie during elections. I mean, how the hell are you going to know? Because they could just say, I'm an idiot. Unless they're going to be like, if you're lying, we could stone you. I don't know what that's really going to do, but that would be base. You could if you lie, we get to throw rocks at you. The lottery style. So they point out the embedding arguments fail. Another L, chat, just L. Section 230 of the Communications Decency Act, where they point out that Section 230 says no provider or user of an interactive computer service shall be treated as a publisher or speaker of any information provided by another information content provider. That means Twitter is not liable for what you say. You could still be held responsible for it, but they are not going to be treated as the ones who said it. You are. And they point out it creates a federal immunity to any state cause of action that would hold a computer service provider liable. It does not clothe the internet service providers in immunity from laws pertaining to intellectual property. So that's a pretty quick one here. They point out that the contributory copyright is under federal law. And they say because those claims clearly pertain to intellectual property, they can't be barred by Section 230. So it's still another L. 3 now, chat. 3. They say the defense failed to carry their burden showing that the fair use bars Russell's claims. And they point out that fair use is an affirmative defense to copyright infringement. And the proponent carries a burden of demonstrating it applies. Yes. And yes, there are 4 factors in fair use: the purpose and nature and character of the use, whether it's nonprofit or educational, the nature of the copyrighted work, the amount substantiality of the portion used in relationship to the copyrighted work as a whole, and the effect of the use upon the potential market for value of the copyrighted work. And they point out that fair use is a mixed question of law and fact. So ultimately, they say the fact-intensive nature of the defense is typically better solved at summary judgment or a trial. Let's see. What are you guys? What is going on here? Who is trying to? Oh, I hate this. My Discord keeps blowing up here, and it won't stop. And it's but nothing's happening. It just makes that noise. I'm like, oh, and actually, shit. I forgot to grab water, chat. Give me 1 second. I will be right back. I need to get some water. So give me 1 second. Water with D's in it. Give me 1 second, chat. I'll be right back. Yes. Sorry, guys. We're having a conversation. All right. All right, chat, we're back. Sorry. Like I said, the bathroom is right around the corner and there's a sink in there so I can get water. Now they point out that the Farms and Hardin only presented arguments in the first, third, and fourth factors. They did not address the second factor. We're watching Delicatessen Law, folks. Yes, sandwich law. All right. It's not toilet water. Toilet water. Arlos's bathroom. Do you not have sinks in your bathrooms? Yes, it's tap water. Of course it would be. I'm not worried. It's tap water. Nothing wrong with that. They say the defendant so far, guys, remember, this is just so far. This is not meaning down the road, although this is a harbinger of there's got to be a little more. But remember, Russell has to present more facts. The defense have not carried their burden of showing that they weigh in favor of fair use because they only point out Greer's failure to include allegations in his complaint. And they point out in the first factor that Greer does not allege anybody profited from this, or that there was a commercial nature. For the fourth factor, they only contend that Greer does not allege the market value has been impacted. They point out, though, it's the defendant's burden, not Russell's, to show that those factors weigh in favor of fair use. They also fail to carry their burden on the third factor because those rely on facts and a declaration from Josh. And I'm sorry, Null. And which the court is prohibited from considering on a motion to dismiss. And they say for those reasons, they have not established the affirmative defense of fair use applies here. That doesn't mean they can't do it later, but for right now, they can't. Chiton is saying, who wrote this? This is the magistrate writing his report and findings. Basically, he's doing all the work, and then he gives it to the judge and says, Judge, what do you do? And the judge is going to say, you know what? I like all this. Copy paste. I adopt most of your findings. Or he could say, I reject all of them. Or he could say, I reject some and accept some. We don't know. They also argue the defendants have failed to carry their burden under Rule 12b-7, which are indispensable parties. And the nature of this is because they haven't produced any evidence with their motion demonstrating the nature of the interest possessed by the absent parties. And they talk about the amended complaint and the protection of those parties' interests will be impaired. They also make two passing references to Rule 12b-7. They'll fail to present any argument on that. Therefore, the argument fails, and consequently, their motion to dismiss under that rule is denied. Denied! They got ricated, chat. We got ricated. So because of that, they hereby recommend to the judge that the motion to dismiss should be denied. You have 14 days. Parties are all being sent copies. Any parties file their objections within 14 days are being served. Failure to object can constitute waiver of objections on subsequent review. Yes, you have to, if you don't respond to this, you reject it. Cleveland, Rossman, Lake, Air Dodo. I don't live in Cleveland, though, but basically all the cities and counties along the lake draw from the lake. You know, my town borders like my town has lakeshore. Like my town has parks on the lake. Like, yes, we draw from the lake. It happens. I could taste the mercury in it right now. Hold on. We'll get some nice mercury water here, chat. Let's just listen. Got that nice. You could taste the mercury. So that has happened here. This is on the 11th. So they had 14 days to respond. In the meantime, guess as expected, within 14 days, Hardin and the Farms responded. And I saw some people online making fun of the fact that in this, Hardin says they're in error, but that's all you can do. It may seem funny for him to say the main point of this filing is that's not true. That's all you can say in these situations. All you can say is that's not true. That, like, all you're pointing out is, Your Honor, the magistrate got it wrong. Don't adopt his findings. He got questions of fact wrong. He got questions of law wrong. Here's what he got wrong. There's only so much you can do with these. But remember, the court hires magistrates who they generally, like, they approve of their writing style, their, how their disposition, who they are, and how they act. So they're probably going to write something pretty similar to what the court's going to adopt anyway. Ultimately, at the federal level, it's a little different, but at the lower court levels, you get hired by a judge. He generally hires people who think alike. If you were very left wing or right wing, you would not hire a magistrate who's on the opposite end, generally speaking, because they won't do what you want typically. Do I mean deuterium oxide? Yeah, that's what I'm drinking. Only the finest. Only the finest for Mama Martin's baby boy. Mama Criminal's baby boy. There you go. So they point out here, and this is where Matthew Arn starts. He says this is based on a misconception that excessive motion is ruled by Rule 12G2 or 12BH1A. They point out that even if that was the correct, assuming an arguendo for the sake of argument, what would happen here? As a matter of first principles and a straightforward interpretation, it wouldn't be correct. And they say because Josh's previous motion to dismiss was based on a complaint with radically different allegations, as his personal involvement in the alleged wrongs. And they point out that Russell, his decision to abandon his previous allegations, rationally permits the defendants to argue that the amended complaint should be dismissed for jurisdictional reasons. They also point out the magistrate erred in other ways. He fails to address the request for motion to dismiss should be construed as a motion for summary judgment. And the report recommendation fails to evaluate alternative grounds for dismissal, as this court previously stated it would do so in its orders. And remember, the court has said it'll evaluate grounds for dismissal of this action under Federal Rule Civil Procedure 11. And that covers frivolous and false filing. Remember, chat, Russell has done so many stupid things. The court has said repeatedly, we might dismiss this. There's a bunch of sanctions we're thinking about that are very draconian and severe that could be coming down the pike for Russell. That hasn't happened yet. It hasn't happened here. But it's something they kept talking about. And Matthew Harden's like, you said you were going to do it, but then you don't do what you said you were going to do. And that's an error. You said you were going to do X, you have to do X and consider it. And they don't do it. They point out that it also errs both to the applicable law and the court's own promise in a prior written order that it would be evaluated. It would evaluate and enumerate alternative grounds for dismissal. Now, I think the court's going to say, we did and we decided not to consider them, or we didn't, decide not to do it anymore. I think the court can probably get away with that. I don't know, though, for sure. They talk about the argument. What's the argument? The magistrate erred as follows. He held that the motion to dismiss was barred successive motions. Remember, and he's trying to say, no, we have the right to make a new argument because it's a new filing. But they said the magistrate said that they're barred from raising a successive motion. They point out that this is wrong for two reasons. First, Lawcow LLC never filed a previous motion to dismiss and never adopted an earlier motion to dismiss. So its motion cannot have been a successive motion. Yeah, except you're at this point, I would argue, an alter ego of Josh. You're basically the same person. So he has done that under that logic. And I say, second, although Joshua Moon's motion was successive, the magistrate erroneously held that the new facts alleged for the first time in the new complaint and facts newly omitted from the amended complaint could be raised in a successive motion to dismiss. So the magistrate's already said, you could address this. And once again, they're getting to, you told us to do it. Why aren't you doing the thing you promised us? It's just, they're allowed to do it. Just like a deadbeat dad. I promised to take you to Disneyland. He never does, but he promised you all the time. They point out here that um, they said when Russell Greer filed this case, he named Kiwi Farms a website as the defendant. And they say for reasons unknown to undersigned counsel or his client, this case was litigated with previous counsel, meaning Scortis, citing filings on behalf of the defendants at every stage. And they said even if this court repeatedly acknowledged that a website is not capable of being sued, they say on remand, so as it came back from the 12th district, they pointed out that Lolcow moved to intervene and substitute for Kiwi Farms, a website. And Russell didn't object. And they point out that Lolcow represented in its motion to intervene, it intends to rely upon and adopt entirely all pleadings filed by undersigned counsel on behalf of the defendants such that no new pleadings are required. Well, there you go. That's kind of how you fucking run yourself over with your own words and use it that way. Are you guys really just fighting in there? Like, oh my God, you guys, like, this is ridiculous. Guys need to chill out. We're talking about taking L's, and you guys are running around having a slap fight. We're taking L's to Russell Greer, chat. That's more important right now. Oh my God. Now they point out that they're arguing Lolcow's barred because of the successive motions. And they point out here, first, Federal Rule 12G does not bar successive motions by a party who merely adopts an earlier motion. I mean, it's an interesting argument here. And they says Lolcow did not make a motion, even as the magistrate tells it, at best adopting a motion. They're saying, therefore, it doesn't apply to Lolcow LLC. And they're telling the court to look at the plain text of the rule. They also point out the previous motion dismissed filed by Kiwi Farms, a website, was never adopted. The magistrate points only to an announced intention to adopt earlier filings. Yeah, but if you let me in, I'll adopt all the filings. Well, then you've adopted all the filings. Like if you say you're going to do it, that kind of makes sense here. Oh my God, it is like the cripple fight. This is ridiculous. This is like I said, it's a personal hell I've built for myself. I built for myself. Oh, isn't it just so much fun, chat? Isn't it just so much fun? Makes you want to scream. Makes you want to scream. It does. They point out also it would make no sense for Lolcow to file a motion to dismiss the original complaint or adopt an earlier version because the original complaint contained no allegations of the Lolcow LLC or its liability. I'm sure the court's going to say, yeah, that doesn't count. You basically are the same entities. They say even if you're assuming for the sake of argument that it can be held to this, Lolcow only ever announced its intention to adopt all the filings on behalf of the defendants. The previous motion to dismiss was not filed by undersigned counsel, it was filed by Greg Scortis. Well, yeah, but you're still kind of limited. If you file the motions and you leave, whoever comes after you, or if you come onto a case, sometimes you could be hamstrung by what the previous attorney did if there's stuff out there or rulings that are adverse. Like sometimes you are hosed. And there are times where you can't fix the problem, but it does happen. And they point out that the undersigned counsel has never adopted on behalf of Lolcow or anyone else pleadings from Scortis, but only announced an intention to adopt earlier pleadings undersigned counsel himself had filed on behalf of the defendants. I don't think that's, I'm surprised the court, like that's some high grade bullshitting right there. At least in my opinion, it is. I don't think that's actually persuasive. That's actually shitty arguing. That's actually shitty arguing in my opinion here when you're making that argument. So they point out ultimately summary judgment is being denied. They're saying that Josh Moon is not barred from a successive motion to dismiss. They point out that Josh isn't entitled to a new one. Well, but they argue they can get it. They argue that there's jurisdictional implications um, on this. And additionally, they say that Russell Greer says that Moon should be liable for the acts of his users. They point out Russell said that Josh Moon should be liable for the actions of third parties, in part because those third parties cannot be tracked down. Well, that's going to be a problem. You can't say he did anything with a third party if you don't have any third parties to track down. So that's the thing. If you don't have these people, you're in trouble if you want to do something about it later. They point out that the amended complaint dropped the entire allegations of Josh's personal involvement. And it says that Mr. Greer no longer seeks to hold Josh liable for his own actions previously enumerated. They point out that Josh has also dropped his agency arguments Russell's dropped his thing that Null is liable for the actions of third parties ostensibly acting on his behalf. They argue, though, that the third parties are added as defendants in their own right in the amended complaint with no allegations made. These parties acted on behalf of Null over the aegis of Null. And they say, according to the magistrate, the defendants are trying to have their cake and eat it too. Cake. By claiming that Russell Greer's complaint both mirrors his original complaint and is different. And they're arguing that's not true. You're not understanding what we're getting at here, Judge. But the allegation the amended complaint mirrors the earlier one comes from Russell and not the defendants. And this is where they're pointing out, Judge, you're citing something from the defendant. I'm sorry, you're citing the plaintiff and attributing it to us. And you're like, that's not right. That's not right. The chat fights are not enough to entice me. No, they're not. They're there. Oh. As this goes on, though, they're pointing out that we still need things here. The magistrate talks about the defenses that are relevant. The magistrate casts the alternative argument that these were concessions from the defendants. But they don't explain how Russell Greer is shifting narratives to jurisdiction, including one of the allegations that were dropped that Josh's agents had taken action against him, do not give rise to permissible successive motion to dismiss. Because a lot of stuff is falling out of this, and they have the right to do it again. But the court's saying, no, I'm not granting it. And they point out if Moon is not alleged to have agents taking actions in the Utah desert, if Josh is not susceptible to the jurisdiction of a Utah court, a motion to dismiss becomes appropriate, even if it would not have been under the earlier things. Because if he did this all in the desert, how do you not know where they are? Remember, if it's not in the jurisdiction has to be addressed. Louis, got over your Clyde coin wallet. Well, no, we don't have Louis tonight either. I don't know if Clyde knows how to go rob Louis. And they point out that Greer ultimately changed his facts. And it was enough to establish jurisdiction over Null that he should have the right to challenge it. They failed to, he erred in failing to construe the motion to dismiss as a motion for summary judgment. And he's saying that they didn't do that right. They point out that Russell has had no witnesses and lacks any witnesses and admissible evidence necessary. And that is important. Remember, we talked about this. Russell, we already had the hearing, and Russell's like, yeah, I don't intend on bringing anybody. I have no witnesses. I have no exhibits. I don't know when I'm going to offer myself at some point. That's all he's got. That's all he's got. And, I think places would be conscious of that. But they aren't. They aren't. I do think it's right. I forget who said it on there. They basically don't give a shit about processing this case. Do I think this is anti-farms bias? No, this is just a judge who doesn't want to deal with it. And this does happen. If you have a problem child case, courts, I've been sitting there in a courtroom before, you can hear a judge whining, not necessarily whining, but lamenting about this case they've got coming up. And since you're not on it, the judge will talk to you about them sometimes. And you can learn some stuff in these cases, and they're hilarious in their nature. How about we keep the tar jousting to a minimum, chat, tonight? Everybody just relax and let's all cope together. They point out that Russell's lack of witnesses and admissible evidence dooms his case at trial. And it makes little sense to continue the case on the basis of pleadings when Russell said he can't produce any evidence. And I would agree, it's the same thing. Bob Toot says, someone joust me. They point out the magistrate declined to hear Knoll's declarations. They point out he failed to consider alternative grounds for relief. They point out that Russell's engaged in flagrant repeated misconduct. You know, that everything Russell's done has caused them to either file motions or be late or have to get basically, how to handle all of this. And they point out that specifically Greer is defiant, and the court notices that he's recalcitrant in the face of the court's orders and that order that he produce a document he claimed he could possess and would be happy to provide. Remember, it's all that crap out of Utah with the protection orders and the restraining orders he didn't file. And what happened to Somali rules? Well, there's a rule in Somalia. Who is in charge of Somalia? Mohammed Farah Adid. And guess what? I am Mohammed Farah Adid. So. They point out here, though, that Russell offered to produce documents of discovery, and the court warned Greer that consequences of his continued noncompliance would be dismissal under Rule 41. And yeah, the court's going to find a way not to be involved with this. They don't want to have to do it. They talk a big game, but then they're like, oh, I don't really want to get involved like that. That's just not good. I don't know if I like it. Everett Scott says, I'm the captain now, bish. And this is also that hearing that I believe we have the recordings of. If they're just not produced because Russell doesn't want to get to it, then we'll be talking about sanctions. And they point out over 3 months ago, they alerted the court that Russell was still out of compliance with that order and subsequent orders denying Russell's serial motions to reconsider. Remember, Russell kept filing a motion to reconsider on this. As of this filing, Russell remains out of compliance with the most basic obligations to obey an order granting a motion to compel, which is over a year old. And that we have to do something about this. We have to. We have to do something here. They say, so in short, the magistrate erred. And that's all you could say. He got it wrong. He got it wrong in that, nobody considered the dismissals under Rule 37. And it says any fair analysis now a year has passed would bring this to dismissal. And basically they're saying, don't adopt it. You should grant the motion and dismiss. And because Russell remains out of compliance. And this is Matthew Harden's response. We are not starting over. Gonna have to suffer. I took a swig of that tap water. Yes, I did. I understand some places you guys have real crappy water. Like, I've been in places in New Jersey before where the water's so nasty and they have water softeners and you take a shower and you never feel like you actually took a shower. But yeah, no, we're not bad like that. Meme copium. I guess we can get along again. You like trains. I like trains. You like stonies. I like stonies. You like tap water. I like tap water. Adam says that's all of New York. Ugh, that sucks. So after that, Russell Greer kind of comes out of nowhere. Russell Greer comes out of nowhere and he files, and it's funny when he files this because it's still the incorrect address that he no longer owns. So I don't know why he's doing this. because this address doesn't exist anymore. But I'm sure Russell would try to cite this to YouTube as something they should ban. So remember, we got to take care of Russell because we don't want him to cry. We don't want him to cry, chat. Actually, hold on here. That's why. Ooh, I don't want to do that. You guys will be able to see everything after I made it transparent. That's not good. Oh, that'd be embarrassing. So what happened in the meantime? Well, Russell filed another motion, and this is in support of electronic filing number 441. And what's number 441? Well, number 441 was a response filed regarding that was a response to Russell filing AI cited cases. Remember, that is something Russell started doing where he started filing cases and Harden was noticing they aren't the right things. They're not even close. The court, they're different courts. It's in the wrong court. What the case is about isn't even correct. Like there's all kinds of issues that Harden was bringing up for Russell that he wasn't doing things right. Well, he's filing authority in support of his own motion saying, actually, I'm correct. So we're going to get this real quick here. Addition to that, one of the things that Russell has had to deal with is also the issues of Russell has a lot of protection orders out there from women. In particular, in Nevada, a lot of the professional sex workers, you call them hookers if you want, have taken out protection orders against Russell. Apparently, Russell is a massive creeper and has been either aggressive and displayed violence or, from what we can tell, may have gotten violent with somebody at some point. We don't really know for sure, but he's weirded out women enough that they've gone to the court to seek protection. You could call them hooers. Yes, you could. Yes, Russell Greer says, have sex with me for free! Oh, this is where it goes from here. And then it goes from here. This is Russell stating there's a case of City of Orem's docket entries for the case of City of Orem versus Russell Greer. The defendants are waving around like a flag of false pretenses to paint Russell as dangerous and to warrant inclusion of Natalie Banks as a witness. I mean, if we read this chat, it's going to be great. This is actually hilarious to read here. So the attached docket shows the opposite of dangerous. Take a pin and you're going to put a pin in that one because that's actually we're going to get to. So the exhibit shows that on 8/17/2022, Greer's 2020 conviction was reduced to a Class C misdemeanor. In other words, Greer has the functional equivalent of a traffic ticket on his record. But it's not a traffic ticket. It's not a traffic ticket. Not only was the assertion that Greer is dangerous hurtful, it hurt his feelings, it was extremely nonsensical. No, I'm pretty sure it's obvious. This is why sites like Kiwi Farms are bad and dangerous because they don't update facts that are inconvenient to their narrative they portray of complete strangers. I swear to God, this sounds like Darkside Phil writing this. It sounds like Darkside Phil. It's nonsense to say a person with the functional equivalent of a traffic ticket is dangerous. With disestablished Natalie Banks, remember, the sex worker who operates out of Akron, Ohio, chat. That's right. Home to Cyrax, home to Natalie Banks. Once again, chat, maybe at some point we'll go down there and interview her. I don't know. Interview her on the job. It's like, I don't know which Akron area titty bar you can go to without getting shot. But anyways, Russell wants her struck as a witness. Respectfully submitted, Russell Greer, my left foot. So what happens from here? What happens from here? Kurt says, I forget how much I hate you sometimes, chat. I hate him too sometimes, Kurt. It's part of how this works. It's the Jungian thing. It's the Jungian thing. I do some days myself. Jorgen Munt says Ohio's trying to take over the log cow nexus from Virginia. Yes, we are. We soon will have all the infinity derps. Oh, it's been hilarious. So, anyways, here is sorry, I was just reading chat. You guys are going like you guys are spurging so hard. All right, so here's the filing Russell put together. This is the docket entries. Notice Russell went ahead and got these, so that means you should be able to get the other ones. This doesn't help his case that I can't get stuff. It's a hardship. So what did he have? Electronic communication harassment. Okay. It was amended to a Class C misdemeanor. He also had another one of electronic communication harassment. And what happened from here? What happened from here? Well, Russell, it appears Russell still might owe some Russell still owes $510. Total amount due, total amount paid. He paid up his bills. So Russell paid his fines and costs. Now, what happened here? Well, we'll get down to the sentencing. What happened? Well, the plea was held in abeyance. The conditions of the agreement for Russell is Russell's ordered to obey all laws and have no further violations during the plea and abeyance diversion period. Russell has to notify the court at all times of his current address. Russell's ordered to pay court costs. Russell's placed on a plea and of abeyance period for 12 months. Okay, all that. Okay. He's placed on a plea and abeyance for a period of 12 months. He has to comply with the terms. He's not to have any contact with the victim. Okay. And they were going to set up review dates for him. They were going to set up review dates on this. You're like, okay, that seems like some sort of stay away order or how this is going. You're like, okay, I can handle this. As this goes on, there have been some. As this keeps going, there was a hearing to reconsider the plea. Less than a month later. So you're like, wait, what happened? What's going on here? So the court sets aside the plea in abeyance. Uh-oh, Russell. Oh, so what happens? Now they keep going here, and this case keeps going. You keep digging around, and ultimately, months later, in September of 2020, guess what Russell Greer has to do? It's pretty straightforward. So, victims counsel motions for a defendant to be ordered to complete a psychosexual evaluation. Yeah, because that happens. You do psychosexual evaluations when you get a parking ticket. Notice what the court says. Based on the convictions of electronic communication harassment, a Class B misdemeanor. So what does that mean? Whatever Russell had set up here, all this stuff about pleading out to this abeyance period, he had some sort of diversion worked out. It didn't stick. Ultimately. It did not stick here. So you're like, okay, well, what happens? Russell is sentenced to a term of 180 days in jail, and they are suspended. What are they to do here, though? The orders of probation, all this, follow the laws, do all of that. Russell's ordered to obtain a mental health evaluation and provide proof of the treatment. Russell's ordered to report to a court-approved treatment agency within 48 hours and to start court-ordered evaluation. Complete your assessment within 90 days and show proof. You have to go to the city offices to be fingerprinted. And you also have to complete the psychosexual evaluation, but that stays that order at this time. Remember, this is a traffic ticket at this point. What the hell is this? What the hell is this, Russell? What the hell is this, Russell? It was just a traffic ticket. That seems like a lot more than a traffic ticket. Yeah. Yeah, I know. These parking tickets are out of control in Utah. You have to get fingerprinted for a parking ticket? It's just, Seller says, I thought they only did these for PDFs. Yeah, well, if you're displaying an inability to maintain your chill and it's like women you're stalking and harassing, courts will get involved in this. Edward Scott says, wait, they got this discovery. Well, Russell provided the court documents. So, yes, it's a human trafficking ticket. Oh, yeah, chat. Oh, yeah, chat. So, oh my God, it's so funny. It's so damn funny. So ultimately, the charge was eventually amended to a Class C misdemeanor. Okay. But that was after he did his psychosexual evaluations. He did all his stuff here. But Russell, we really know what you pled to. You're harassing women. You were harassing women. Brave woman, and Russell was harassing them. Russell Greer fought so hard, I'm surprised he turned it over. Well, I think he thinks this makes him actually look reasonable. Like, see, they cut me a deal and amended it. It's like, yeah, but they still think you're a psychopath. And apparently you're not allowed in all the whorehouses in Nevada right now. Almost all of them have banned you, I think, is what's, the sign of what's going on there. So that is Russell's, this is Russell's actionally. It's like, okay, good job, buddy. I don't know how that works for you, but okay, Russell. Okay. Maybe we really are coping, chat. Maybe we're really coping. So what happens here, chat? Well, ultimately, the court has to make a decision on whether it accepts the magistrate's findings. And we're not going to rehash a lot of this here because guess what? It adopts the it adopts the findings of the magistrate and it overrules the objections. So it adopts the report and recommendation, meaning he takes that and adopts it as his own, and then he adds his own thoughts into this. So they go through all this, and like I said, we're not going to go back through this. It's all him just reinforcing what we've heard. Cyanide Cologne says that attorney is a Pokemon? Who? Who's a Pokemon? I don't even know what the hell you guys are talking about now. What did I miss here? Yes. Oh, Samus is saying it's a human trafficking ticket. Yes. I still think it's funny, guys. I still think it's a hilarious joke here. Oh. Now from here, the court basically adopts everything. And ultimately it goes through all this. I'm not gonna readdress all of this, chat. It's already been said there. And ultimately, the report is adopted. The defendant's motion to dismiss is denied. Not even in part accepted. It's just been denied. Once again, chat, we got ricated. It's a Digimon. Who likes Digimon? I always thought Digimon were like the Aldi brand Pokemon or something like that. Oh, yeah. I don't think, yeah. Oh, Digibro. Oh, yes. God, what a freak. Yes, Digibro is. No Digimon slander. Suffa. Digimon came out around the same time as Pokemon. It did. It was just really gay. I was like, this is like dollar store brand. It's like Family Dollar Pokemon. Oh no, Fair Frozen's getting mad. No, they're not. They're real to me. My favorites. Oh, Digimon won't do what Pokemon can. Make money, yes. Yes, maybe we're actually the lol cows and lol cows are normal people. Digimon is somehow more pedophile coded than Pokemon. Really? Huh. Interesting. So anyway, from here, because everything has been, the motion to dismiss is denied. Matthew Hardin immediately kicks into gear and switches gears and says, all right, well, it's time for a discovery. Let's get back to the grind of discovery here, because that is where Russell was starting to suffer problems. Remember, Russell keeps racking up sanctions because he fails to comply with discovery. So they want a motion for a scheduling order or alternative relief. They want to move forward with discovery and keep hammering Russell because that's where he fucks up and he's not willing to cooperate. And it makes sense. Keep going on him. Keep going on him. And they say that they request the court impose a scheduling order to govern further proceedings in this matter, or grant the motion as follows. The court, and they go back to, and the court imposed a schedule by order dated November 8, 2024. That schedule was later amended by the end of the 2024 in December. Then on May 7th, following the initial round of noncompliance, the court entered an order stating, with certain exceptions, all other discovery is hereby stayed pending a rule on the motion to dismiss. So up until that point, up until May 7th, there was discovery that was supposed to be going. And then finally the court said, well, you guys are launching stuff. We're just going to wait. You get all your stuff out there. You're filing a big motion to dismiss. You're going to do it. We're going to wait to see what happens. They point out that the motion to dismiss was denied on March 13th. Therefore, they believe discovery stay has expired, and they wrote to Greer to inquire as to his position. Russell thinks it remains stayed, and they have an email for that, which, okay, Russell might be a goober, but that still is a fair argument of like, okay, judge, what should we do? Are we back to the grind again? And they say, as per his pattern, Greer violated the court's orders of multiple times. He has continued not to comply with the orders, granting motions to compel. And despite the passage of over a year since the court's initial deadline and multiple things for reconsideration, Russell hasn't done anything. And they say, and Russell Greer obtained from the clerk 2 subpoenas during the pendency of the stay, which were later voided. And he says there are multiple pending motions for sanctions against Russell. As a result, it's non-compliance. You're like, well, you got to do something, and nothing is happening. Yes, it's the Greer grind. And this is where it's like they're just highlighting all the problems. And these judges they're just like, don't care. And it's like, why can't you? Why can't you care about this? Oh. And they point out that this case should be dismissed as sanctions for the continuing and blatant noncompliance. And they point out that this court warned Russell this would happen. And he says we're going to be talking once again about the Rule 37 sanctions of case termination for failure to cooperate, which could include fees. And they want the court to enforce its own oral and written orders. And yes, judge, do what you said you're going to do. And they're saying if you do what you do, we're all done. It says, however, this court is not inclined to dismiss the cases it said it would for non-compliance with its own orders. And that's true. They're just doing whatever the hell they want here. The defendants respectfully submit that it should hold a new hearing and impose a new case schedule. They note that the position is Russell has failed to comply even with the most basic request, so a newly imposed schedule may need to account for the extensive delays Russell has caused. They say alternatively, this court could simply close discovery relating to Russell's claims and based on that. And chat, that's a sanction as well. If you're violating discovery or there's problems with discovery, the court can come back and say, as an option, discovery's done. You are not allowed to get any more discovery, which you might say, well, wait, how does that work? If you're like, I'm trying to investigate a matter, the court's going to say, oh, that sucks. I don't care. We're done, sir. And that can happen. That can happen as a viable option for a court to sanction you if you're not cooperating as part of discovery. Because remember, as the plaintiff especially, you're the one who wanted this case. You're the one who filed it. You wanted all of it. Well, you better fucking cooperate. You better cooperate. Yeah, 454 docket entries is complex litigation, and it should be. It should be. Bella's saying this Russell case has become boring. Yeah, it has. It's become drudging. It's mundane. It's boring. It's a slog, and I think that's part of the reason why the court's staying out of it. Anonymous is the judge. I think it's just rough. I just think they really don't want to fucking deal with it anymore. If I had to guess, and oh shit, the sticker peeled off. I better put it up on my safe. Hold on, chat. There we go. Okay. I've been messing with this sticker forever, and I was like, if I start playing with this, I bet it comes off, and sure as shit it did. Such is life. They also point out that they recognize Judge Barlow's order saying that Russell will not present any witnesses. If there's no sworn testimony, either under Rule 56 or a trial, the defendants would be content to close discovery and impose a schedule allowing this matter to be set for dispositive motions and trial. Yes. Remember, this is something they wanted to do before. Judge, let us go to fucking trial. If we're not having anything, let's just go. So they say they want a scheduling order or dismiss the case for the reasons above, saying, stay true to your word. You promised you would do something. It's your turn to do the thing. And he hasn't done the thing. Hold on, chat. Oh, shit. HKparts.com is selling $159 G3 parts kits. Hell yeah. HKparts.net, chat. You can get the Portuguese contract G3s, which were made on HK tooling. They had a license. Just a fair thing out there if you want to know. I can't show it to you, but use your imagination. So what do you do here? Well, they're asking for things. And this is an email from Russell Greer that was cited. And Russell says, as an idiot here, Russell's still trying to get those two users, Mosif Jartelli and, Rustard. Those are the two people he's going after. And he says, I thought discovery has stayed until the two John Does have been served. They haven't been served yet, which is why I tried doing the subpoena on QB Farms, so they could be served. So discovery has stayed until the judge rules otherwise. And this is just pointing out what's going on here now. Everett says, any of the parts kit barrel band has been great. Yeah, well, these ones already, these ones don't have, these ones, let me see here. I think they come with the, is it just, okay, hold on here. Does it come with the barrel, or is the barrel garbage? Hold on. HK Trunnion with barrel pin. Yeah, I think the barrel's been cut on these, so there's no barrel in these parts kits. So I'm assuming these were pre-imported before the barrel ban. So suffer chat. David saying, since he didn't serve them in 90 days, does he even have a chance? Who? Russell? I mean, none of this is going to change. The court's not going to toss the case. I think this court is worried about getting overturned again by the 10th Circuit. So this is going to drag on. I also don't think they want to deal with it. I talked to Hardin about this, and I told him one of my theories is I think all the filings and stuff he's done has kind of like not necessarily pissed them off, but made them really not want to deal with this. I think that they got out over their skis a little bit. Like, I get it, when you're A-logging Russell, but I think this got the court a little bit. This made them really throw it into the don't care pile. So, yeah, they're fatigued. And I think that's part of the issue here. So, and also, David, I'm not sure what you mean by the 90 days. So if you want to compound or expound more, let me know. So, Cecilium says, fucking thank you. Of course, the judges are pissed off at both sides. I think they're more upset at Harden than they are at Russell at this point. And like I said, I don't think they're pissed. I just think they're just more agitated and annoyed because we're at 454 goddamn filings. Throw it out with prejudice. Well, they already tried to do, like, they already dismissed the case once, and the 10th Circuit smacked the court's pee-pee. These judges don't want it to come back. They want to be done. And it's actually easier. It's just like your guys' jobs in real life. There are judges who they have a case or two where I've made that joke before. They've got their stack of crap they work through. And as that case comes up to the top, they take it. And just like in casino, you apply for a new job, you change your job title, that goes back to the bottom of the stack. I think that there are courts that do that. I've seen courts do that. I've seen judges, kvetch and complain about cases they have coming up they don't want to deal with. Like, it's not uncommon. It's not an uncommon thing. You find yourself fatigued when it comes to lawyers. Well, we are what we are. So it'll be interesting to see what the court says here. I think the court's going to say, go forth and do discovery, which I think it should. Like, get discovery done. We'll see. We'll see. We shall see on that. And with that, guys, we are actually, I think it's all caught. Yeah, we're all caught up. We are all caught up to Russell's little insane spree through the Utah court system. And once again, he is trying to use all this garbage nonsense of which I don't understand it. I don't understand it. I think, like I said, I think they pissed a little bit. I think Harden and them should lay off a little bit. Just do the bare minimum of things you have to do and address the problems. But I don't think we need a million fucking filings for a while. I think unless Russell does something really egregious, I would just leave it alone. I have not sat down and tried to lecture him or be like, give him a dad moment or anything like that. I just think it's something to consider. I just think it's something to consider. Um, I don't know though. I don't know though. What do I know? What do I know? I'm the fat man. I eat sandwiches. I eat sandwiches. I should do a Greer filing tier list. Oh, David, you're saying talk about 90 days to serve the new defendants after the amended complaint. They've tried I don't think the courts are going to mandate that at this point. Even if they try to serve parties, the court's not going to let them. If you try to argue Google needs to be in here, they won't. And I think that was a big mistake Scortis made because we see in the Stebbins cases, every time Google gets brought in or YouTube gets brought in, Google's attorneys show up and they just fucking kill the case right away and smack it dead. So the court should deem Russell incompetent and force him to get a lawyer or fuck off. Well, no, he's doing just enough. He's doing just enough. JCXE is saying the fact they haven't sanctioned him and he still hasn't produced the documents is just dumb. Well, they have sanctioned him for different things. But remember, I think the courts just are fucking tired of this. And like I said, I think part of the problem for Harden is, you're filing all this shit and we're now dealing with all the gay nonsense about the fucking whorehouses out in Winnemucca. And it's like, I think we're really getting a far afield. I do think it all goes towards Russell's credibility and he's lying before the court. But I think some of that should have been left alone at this point. And I think the court's just like, we're fucking done with you. And but you'd say, well, also on the other hand, maybe why'd they just get rid of it? Well, remember, they're terrified of that. So I think they might make this go to trial just to wash their hands of it. So turkey or tuna fish sandwich, Sean. If it's really good tuna fish, I like tuna fish. I like tuna fish. But the court is tired of it. They should just do their job and finish the case. Well, You also need to remember these are governmental employees. So governmental employees do governmental employee things. That's a problem here. Tuna is rank. No, it's not. Tuna's good. I drink Flint runoff water and eat sandwiches. Pork chop sandwiches. Oh, I'd fucking eat those all day. Smoked turkey's still good. Turkey's still a good thing to eat. I still would eat it. I'm just saying. It's I like tuna fish a lot. But you don't even need tuna fish. Like if you're gonna do tuna fish, it's gonna be like on toast. So I so hard as mud wrestling with a pig. Yeah, I mean that becomes part of the issue after a while. And I think that ultimately, I think dealing with him enough. I think the courts want to be. I think the courts just want to like just fucking stop. So I think it's best for them just to like stop for now. That's my recommendation is just like and let stop and don't do anything. Remember, because as a defendant, you really don't have to do a whole lot affirmatively. Let Russell not do anything, and eventually the court's going to say, "What the fuck are we doing here?" I think that's probably the time to get back in the game. I would take a little bit of a break here and really step on the brakes and just let off the gas for a second. Russell should be sanctioned for his conduct. He should. This case should be dismissed already. But I'm not a judge. I'm not the one handling the case, which sucks. So, suffer chat, which is what we're gonna do. They would dismiss if they wanted to stop. Well, yeah. James Reed says Sean Martin says turkey over ham. You're goddamn right. Turkey over ham. Ham is Untermensch. Also says this what about a great fried fish sandwich? I believe it or not, I'm like I'll eat like fried perch. Because like if you get perch out of the lake and you fry it up, it's like eating oh god, it's like eating oh, those are so addictive. I could eat a million of those. But in general, like fried walleye or something like that, I'm not a big fan. Normal types of fish and chips where people eat like haddock or cod, like it's okay. Like, not really big on that. Like, I like eating fish that's been cooked. So, like, I'll eat like sole or salmon or trout or other things like that. Even eat haddock or cod as part of like a dinner, but I'm not big like fried fish guy. Not a big fried fish guy. So, I do fried catfish. Yeah, I do fried catfish. And man, Rest is like, what the fuck? What about which part? Which part are you crying about now? Harden may be trying to clear his plate to deal with the Liz Fong Jones lawsuit. We'll deal with that one as there's a response to it. I will say it's funny though that they were, all about trying to harass the farms, and then the farms decides to go after Fong and the Cucks law firm and immediately file an immediate surprise attack with the injunction, and they haven't responded yet. So am I even fat? Yeah. I mean, like, I don't think the filet of fish sandwich is fucking awful. Like, I don't like a ton of fried fish. Like, a lot of fried fish is just ugh. I mean, like, I think that's just because as kids, he ate fish sticks a lot. And it's like all the tilapia and, hot dogs of the fish world really kind of soured me on it. I don't know. I don't know. There's all kinds of other fish you can eat too. Get you dolphin fish or halibut. Halibut's good too. There's a lot of good fish out there you can eat. Um, oh, I didn't see. Is that an update that Liz asked or Elliot asked for 100 days and got it? Wow. Yeah, 100 days. Damn. Well, that happens when you waive service. You can ask for more time. So, fried calamari. Oh, calamari's amazing. That's octopus. That's different. Calamari's good. Yes, tilapia is both the best whitefish and the worst whitefish. I have big guy anorexia, but I'm not a roided out gym bro. Um, grilled barramundi. I don't think I've had barramundi. Pike is good. Pike is good. I don't think I've had like fried pike though, or battered pike. Pan fried walleye is Yeah, walleye's really good. Walleye's really good. What? Okay, what? Hold on. What are you talking about here? That calamari is pork butthole. It's artificial, not real, fake. Okay, okay, hold on. Oh wow. Okay, is most calamari fake? Okay, no, most calamari is not fake. Okay, okay, yeah, okay. Well, I know where you found that out from, sir. It was from an episode of This American Life on public radio. While some seafood fraud exists, it's that most calamari is almost always actual squid. Yes. But the reporter admitted there was no proof of this. Even even though there's pig rectum, I mean, it all depends where I'm going. If I'm at like a local bar here in Ohio and they're like, "We have calamari," I'm like, "That's not calamari." If I go to like an upscale restaurant, like I'll definitely believe that's calamari. So I don't. Red snapper is good. Yeah, snapper is not a bad choice. There's a lot of good fish out there. A good bass is never bad. Squid is cheap. Why use pig butthole? Because it's not real. That's a fake story. Um, the guy at the farm or slaughterhouse told them they sell the pig bung to Asia to be made into artificial calamari. Yeah, that's not true. Google's saying that's not true. That's not true. But it all depends where you're going. That's like if I went to Applebee's, I wouldn't order I wouldn't order like their spaghetti because it'd probably be disgusting. I would go to an Italian restaurant, like a real Italian restaurant. Same way I wouldn't order steak from like Red Lobster for steak. It's like, ugh, why would you do that? So yes, debunked. Boneless calamari. Yes, there's no bones in it. So he go to Olive Garden just like Russell Greer. Oh. Yes, you have to expect yes, according to the Supreme Court of Ohio, you have to be able to expect bones in your boneless calamari. A reasonable person would expect bones in their boneless wings. All right. Oh, we got some super chats to get through too here. Load Alaska's, you missed a few super chats. I am sorry. There were a million of them. EDW Raptor for $5 says, "Can we have a moment of silence for Chuck Norris?" Yes, 86 years old. R.I.P. R.I.P. Chuck. And Chugi Show says, "Yes, it's we need Lamb Chop, the little freaking sock puppet thing to sing the song. This is the lawsuit that doesn't end. Yes, it goes on and on, my friend. Russell started filing it, not knowing what it was, and Harding continues litigating it forever just because." Yes, I loved Lamb Chop when I was a kid. I love that. I love that show when I was a little kid. Ace Ventura for €2. Once again, thank you, sir. Says the era of the nunchucks has ended. Yes, the era of a lot of things has ended. The era of Walker, Texas Ranger. That arc has ended for us as Americans. T-Rex Travel says, "What does the chance of appeal does he even have to me? The judge is so biased in favor of the plaintiffs, there's no grounds for appeal." Talk about Afro Man. They could argue a lot of different things. The jury got it wrong. No reasonable jury would get it right. A lot of stuff you could argue. A lot of things you can argue either way. I don't think they're going to get anywhere. The court's just going to leave this one alone. I think the Court of Appeal is going to say they got to dodge a bullet to not have to address and fix a First Amendment problem. The jury got it right good enough for maybe the wrong reasons, but the right result. And they'll say, good enough. We don't have to make a policy argument. Let's see here. Ark says, never ask a white supremacist what color his girlfriend is. That is very true. That's very true. It's very true. Although for in the case like Nick Fuentes, never ask a white supremacist what non-binary otherkin is his cat boy. Ace Ventura again says, get to the point. What did Greer do? Thank you. Will you cover the one in Hawaii, the Koning trial? I don't know what that's about. So maybe. Ace Ventura says, how the hell can a judge take Russell serious in any way? Well, it's not really that they're taking Russell serious, it's that they're not taking the farm serious. Chet Manley says the appeals courts already told them to entertain the rest hard. Yeah, to an extent. And I think they're just like, fuck it, fine, we'll deal with it. At what point could Greer be considered a vexatious litigant? It's really hard to get there. You have to like make it, you have to like, it's like playing hearts. You have to shoot the moon. I mean, you have to get all the points. And Russell's not even close yet. I mean, should he be one? Yes. But it's tough to get, and I don't see this court dealing with it in that way. Because at this point, remember, his complaint plausibly pled facts that survived summary judgment and a motion to dismiss. So this is definitely not something that can be used against him for vexatious litigation. So a court would be hard-pressed to label him one if he's done enough here. So not for this. Not for this. It's a very good question, though. Trucker Rob says, Sean! Well, hello. I look forward to the other Greer cases, yes. Karen, I'm so sad about the University of Alabama kid in Spain. I have no idea what happened. So, Afton says Koenig is the, that's German for king, Koenig. The anesthesiologist that attempted to off his wife. Ooh, interesting. Interesting. Did I watch Captain Kangaroo? That was a little before my time. I was born in 85, so no, not really. Iman Reza says his gravestone will say, Walker told me I have AIDS. Oh, Keopathic says, I met Chuck Norris when I was in Iraq. He was doing a morale tour, stopped on Al Assad. Yeah, and that was the interesting Chuck, 20 years ago, Chuck is like 66, 67 years old, and he's wandering around Iraq doing like USO stuff. Like, that's based. So, yeah, heard a lot of people like them. So let's say, could Russell be a future case study in law school? Maybe at some point that, like, I think that's something, there'll be classes on sovereign citizens and things like that. Maybe, but I think outside of our little world, remember, we are not the internet. And that's a thing that every group of people, they think they're the baddest bitch on the, they're the baddest bitch on the block and everybody should know who they are. When really, when you step outside of your neighborhood, everybody's like, who? It's like the sector. Like, that's, if you think you're the biggest place in the world, like other than Reddit, most people don't know who you are. So I don't think most people know who Russell Greer is. So probably not. Did they try to revive the Texas Ranger series recently? I don't know if they did or not. Anyone watch The Big Comfy Couch? That was after me. That was like my siblings. I was too old for that. He's a case study in hooker school. Oh, I guarantee you, the women who are hooking know, like, he's somebody to watch out for. Because they've said, like, he's part of the danger on the danger apps. Like, they report him on there. So. Haschick says, I still don't know who he is. He's a guy that's got a face. He suffers from a paralyzed facial structure. Like, his face is really paralyzed. So he's doing there. and this is how he talks. I like, and he um, really has a problem with women. I think because women don't like him, and he's got problems with that. So Russell Greer has tried to sue Taylor Swift and Ariana Grande for not going on dates with him. He's famous for taking a hooker out to Olive Garden in Nevada, and he took her to dinner for the girlfriend experience. And the girl was smart enough to run out the clock in the Olive Garden that she didn't have to have sex with Russell, and Russell sued her for that. Russell has also basically been kicked out of every brothel in Nevada because he's a fucking psychopath as well. My name is Karen. Says I just started watching Peaky Blinders. That is a good thing. That's a good thing. Yes, Russell Greer is one of the people who can remind you that the disabled can be complete scumbags as well. That is true. That is true. Yes. So that is really it, guys. We're all caught up there. I know some people wanted to cover that, and once again, chat, it all can't be if it's not a dub, even if it's an L, we still gotta get that dip slap going. Take that. We're eating that Copenhagen tonight, chat. We are coping and sneeding. We are coping and sneeding. Pickle up, it says Peaky Blinder super violent. Yes, it's pretty violent. A lot of people get killed in it. Although it's based, if you like, World War I era weapons, because it's like right after World War I. So like there's like Lewis guns and SMLEs and Webleys and like Tommy guns and like early 1911s. It's pretty cool in that regard. It's pretty cool in that regard. But yes, Sneed. Yes. Have to cope at Sneed, chat. Have to cope at Sneed. I'm sorry it's not a good one here, but yeah, back to square one for the farms. Back to Discovery. So Harden has already declared one or two of the hookers potential witnesses. Yep. He's already acknowledged those to Russell. Scorehammer says, I missed the stream. Is Russell winning yet? He's still in the game. He survived the motion to dismiss. So yes. Now he's got Discovery. And remember, this is as far as Russell's ever gotten. So he's got to figure out what he's going to do. And I think he just doesn't know what to do at this point. He's like a dog who has the car. It's like, what do I do? And I think Russell doesn't know what to do. So it's a tough spot to be in. When you've been fighting for this thing to happen and you finally get it, now you're like, uh-oh, what do I do? And for Russell, I don't think he knows. So okay, we're gonna do so. Fred just sent me something over on. He just DM'd me something here. This is hilarious. I like this. This is why won't this hold on here? Will this let me? Okay, hold on, chat. I gotta move this. All right, here we go. This is funny. This is this is the Iran war thing related, but we're gonna do this just because it's fucking hilarious and I think it's funny. I had seen this before, but we need a good meme right now. We need a good meme, and this is a pretty good meme. This should be something you guys can hear the sound for. This is the last Iranian F-14, which remember, Iran had a lot of American equipment prior to the revolution, fighting some NASA DARPA prototype the president doesn't even know about. This is kind of funny. We gotta love. Is it love to stay? Oh, lasers. We gotta wham, bam, shang-a-lang, and the sha-la-la-la-la-la thing. Wham, bam, shang-a-lang, and the sha. That's pretty funny. I love that. Did I just fall in a hole? I don't know. Did I? Must be a pretty big hole for me to fit into. Yeah, I bet we are using some of that UFO tech. Project Wingman is a great game. Yes, it is. Yes, it is. What's your favorite Chuck Norris movie? Delta Force. I think Delta Force is a really good movie. The mic's echoing. Is it better now? I have a bad echo. Echo, echo, echo. You have an echo, Sean. Echo, 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 echo. Thank you. Now it's good. Yeah, it was a video. Sorry. I just thought that was hilarious. I thought it was a hilarious thing to end on. Sidekicks. Oh my God, I forgot about that movie. I remember seeing that. I think it was like my brother's birthday one year. My mom had rented a bunch of shit for his birthday party. And I was like, whoa, that was a good fucking movie. That was a good movie. Cyanide says, is Iran out of tomahawks? Tucker sold them during Iran-Contra to blame the USA for bombing schools yet. Oh. Chuck, the Delta Force, Chuck and Lee Marvin. It was really good. I really liked it. You know, that was really good. I like their little dirt bikes with the little missile launchers in the front. It's like, when is Ready or Not? Tomorrow night, guys. Tomorrow night, 8:00. We are going to start playing Ready or Not. If you guys don't know what that is, I mean, it's you operate as a police tactical team, but it's, short of playing like Ground Branch. It's pretty good as far as, like close quarter combat and stuff. We're going to play it. It's been like a year and a half since I played it. I want to get back into it. So we're going to try that. We'll do that tomorrow night at 8. Actually, yeah, I'll be getting ready around 7:30. We'll try it at 8. EDW says Iran tried to hit Diego Garcia. Well, yeah, I mean, we didn't know they had that range. Of course they have that fucking range. They can hit Romania if they wanted to. They can hit some of the Aegis Ashore locations we have in Eastern Europe. It's not that hard. Diego Garcia is not that far from Iran. It's actually pretty close. So, how many signals do you have? A couple. Try not to A-log. I try not to dox them. So I have a couple. Am I going to go full lethal and Ready or Not? That's the only way to go. It's the only way to go. We're not doing the fucking non-lethal routes. Fuck that. We're going to stack some bodies, chat. We're going to do a couple of missions where it's just kill orders. Green lights on people. Oh. Yeah, Ready or Not is on sale on Steam until the 26th. Do you know if they confirmed the F-35 hits? Well, some of the F-35s did get damaged. There's at least one that made an emergency landing because it suffered damage of some sort. I mean, the idea that you can't shoot one down is ridiculous. The F-117s got shot down. I mean, it's radar. You're eventually at some point, like you open you open one of your bomb bay doors, gonna get highlighted. There's a bunch of different ways things can happen. Dub luck. I mean, we've flown a third of the total sorties. They flew like 40,000 sorties for Desert Storm once the war kicked off. We flew like 40,000 sorties. We've flown like 15,000 sorties so far between the United States and Israel and the IAF. And like, the actual only combat loss right now is to the Iranians is a fucking F-35 that maybe fought at a missile. It's pretty fucking good. Pretty fucking good. So, Tristan says 2,500 miles is pretty close. I mean, in terms of how far Iran can reach, yeah. Yes. Eric says that it wasn't great. It was a massively exaggerated capability. It was enough that it scared the shit out of the Russians. So, is there friendly fire? Well, yeah, there's friendly fire in Ready or Not, yes. So, Katie says I make a great support team member. No, I need shooters. Everybody's got to be a shooter if they're on the team with me. We're going in. We're no survivors. No survivors, but no Russian either. Remember, no Russian. The Serbs only got one F-117, but it was still significant they got it. We had to bomb yes, they got one F-117, and we had to bomb the Chinese embassy in Belgrade because of that. Because they trucked pieces of it into the Chinese embassy, and we had to send a fucking cruise missile into the Chinese embassy to destroy those pieces. We didn't accidentally bomb the Chinese embassy. That was pretty intentional. Can you guys play with me? Yeah, sure. We're going to need people. There's like 5 people. There's like 4 people total. I need. Yes, we need. Yeah, they have Glock 18s now. So yeah, everybody can have a blicky. Yep. I only play Muda though. Meat Candy says, I know to aim at the shadows with smiles. Well, we'll figure something out there tomorrow. We'll figure something out with the teams and the game. Karen says, I've got to write a motion for family court in the next 3 days. Well, there you go. We'll just take your time. Tell them what you need. If you're asking the court for something, just tell them in plain terms what you're asking for. Can you play as the enemy, or is it only the good guys? Only the good guys. So it's only the good guys. You can only play as the police, sadly. You can't play as the bad guys going after the cops. All right, chat. Well, with that being said, we are going to friendly fire check on Sean's team. Checkmate. Yeah. The good guys is highly subjective. Well, thank you. Yes, EDW. Yes, we could go raid. That'd be funny if somebody made a map of Afroman's house and like one of the objectives is secure the pound cake. Oh, that would be so funny. That would be hilarious. Oh, I crack myself up sometimes. All right, chat. With that said, we are going to head over to the bench. I'm going to keep working on the elephant here. We need to make some progress. Hold on here. We got a lot I think we're going to get to. We're going to get into the photo etch parts tonight as we start putting them on. It's actually going to be a lot of fun. And hope to see you guys over there. I'll redirect us over so you guys can join us. But it's been a lot of fun working on this. It's nice to work on like a full-size project. And it's nice. You go from 156 scale. It's like little things. You know, you go from like this at 156 scale to like 135th scale. And it's like, boom. It's nice. It's nice. It's a great change. So 20 years ago, that have already been a Counter-Strike map. I know. I remember there was a kid who made, like we had like Counter-Strike maps of like our school. That didn't last very long, but like there were all kinds of funny Counter-Strike maps out there. All kinds of funny Counter-Strike maps. I remember those days. All right, chat. So we will do this. We'll end up here. I think there's going to be, I think that's going to be it for us. And yeah, once again, back to the lab again for Matthew Harden and the Farms. Russell Greer survives another day. I know this wasn't interesting. This is a cope stream, but hey, sometimes you have to cope and sometimes you have to sneed. It's, such is life. Such is life. Can't do anything about it. Is this not even showing up? Wow, I type it in. It doesn't even show up where I need it to be. There we go. All right, chat. So just remember till next time, just because you did it does not mean you're guilty. Good night, chat. And I will see you guys later. Here it is. Come on. Click.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking.
No, I don't have any of the DLC. And it sucks because they kind of nerfed a lot of things. So, yeah, the AI is going to be a little tough, but, I mean, like, we'll have to figure that out. Like, we'll suffer through it. I forgot all the downloads. Devil Eyed Elvis told me about all the downloads I need. I forgot which ones I need, but no, I don't have any of the DLCs. I don't have any of the add-ons. So it's just stock for me.
Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on.
Really? Okay. I did not know that. That's good. So we can do it where somebody's got all the extra gore and all the original stuff back in it. Cool. I didn't know that. I'll have to figure that out tomorrow. Good to know.
Have you on illegal stops? Just cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy that Kaden yelled?